heard appeal in the matter of InterDigital Technology Corporation and others, Lenovo Group Limited and others.
Yes, Mr. Seeger.
My Lords, when we broke, I was in the course of developing my submissions on the first of the 8 reasons why we say Ground 8 should be dismissed. And on that point, I showed the court yesterday, firstly, the court's identification of the issue as to whether the lump sums in the Lenovo 7 were or were not the best evidence of a FRAND rate. Secondly, the judge's rejection of the case that those lump sums embodied or could be explained as including substantial volume discounts. Thirdly, the judge's rejection of the same case as regards the other discounts contended for by InterDigital in a passage which included reference to past sales. And fourthly, the judge's specific findings about the circumstances in which each of the Lenovo 7 came to be concluded, in which he considered the evidence very carefully and reached conclusions as to the circumstances in which they had been concluded, and appropriately nuanced conclusions as to whether they could be taken to represent the true value of the portfolio. Expressions like slightly low, a counterbalance, an upper bound, and the such like. Those findings are in themselves, as we submitted yesterday, not reconcilable with the contention that the lump sums in the Lenovo 7 were multiples below a true FRAND rate. But the relevant findings do not end there, however, and to complete the review, we therefore need to look, if we may, at paragraph 722 onwards of the judgment at page 180. And this is where the judge returns to the general argument about holdout and the value of the portfolio. And we can pick it up perhaps at 724, where the judge notes that there were 2 striking absences from InterDigital's evidence. The first being there was no evidence to the effect that the Lenovo 7 cannot be relied upon at all because all those deals and the rates implied from them were massively affected by holdout. And for example, only the PLAs consistent with InterDigital's program rates were FRAND. And I shan't read the rest of that, but my Lords can see it. And the second was that InterDigital did not develop a case in what I might call the middle ground. By that I mean that no case was presented that the Lenovo 7 were affected by holdout and resulted in rates which were, say, 20% below the true value. Instead, InterDigital's case was that the true value was multiples of the rates which were derived from the Lenovo 7 on a straightforward blended analysis. And that, of course, is the case that InterDigital is advancing on appeal. My Lords, then there's reference to the declining rates, and then paragraph 726. I'm driven to the clear conclusion that aside from the observations I have made based on circumstances specific to certain of the Lenovo 7 PLAs, there was no evidence of InterDigital being forced by extensive holdout to grant discounts of 60%, 70%, or 80% to the largest licensees. My Lord, when Mr. Speck took you to this part of the judgment, that's where he stopped reading. The judge goes on, or that the PLAs with the Lenovo 7 imply rates which are far below the true value of InterDigital's portfolio. If InterDigital really thought those PLAs were far below the true value of their portfolio, it would not have been economically sensible for them to agree them. And then I can pick up at the end of that paragraph. Instead, in my judgment, the Lenovo 7 are the best group of indicators of the value of InterDigital's portfolio, precisely because they are the result of InterDigital's own assessment of the value of their portfolio for the largest licensees. 727, he says, having dealt with the rather extreme argument, I should also consider whether the Lenovo 7 were affected by a degree of holdout. 728, it's clear that InterDigital have been affected by a degree of holdout. but the issues are one, whether the impact is reflected in the royalty rates in these PLAs, and two, if so, to what extent. Now, the point I make about this paragraph is that the judge makes express reference here to his factors in relation to difficulties of global recovery and the perceived influence of national limitation periods. So the judge certainly hadn't forgotten those points. And here we have at the end of this paragraph, however, that second point has undoubtedly been a or the principal reason for the practice which had grown up of heavily waiving or heavily discounting past royalties, etc. So the judge was clearly alive to that point here. 729, this is a paragraph which Mr. Alexander read to you. Last sentence, InterDigital has developed ways to cope with the two obstacles I mentioned above, and this has led to considerable distortion, particularly in future rates, which can be derived from their PLAs. The judge then considers at 730 two hypothetical situations, the first of which is before the licenses have been concluded, the second of which is after. In the present situation, InterDigital now has a considerable body of PLAs, including the Lenovo 7, i.e. PLAs with some of the largest implementers. It seems to me that having concluded 7 PLAs with some of the largest implementers, there is force in Mr. Meyer's suggestion that InterDigital has now established something of a market rate for their portfolio. And I pause there to note that that market rate includes, of course, rates derived from licenses where there were no past sales at all. Returning to the judgment, it also seems to me that there must come a point at which the allegation of holdout ceases to have force. Against that, InterDigital would no doubt argue that a degree of holdout has been baked into their PLAs. And at 732, the judge makes the point that if a degree of holdout has been baked in, the issue was to quantify it, and that he had been given no means of quantifying that by InterDigital because of the jackpot case. And at 734, the judge says none of the analyses allow him to identify whether a degree of holdout has been baked into the licenses, but that he would continue to take into account where I have found that the rates derived from some of the Lenovo 7 are on the low side due to pressures on InterDigital. And we do say, my lords, that InterDigital's case on appeal cannot be reconciled with these findings, all the other findings I went through yesterday. InterDigital's case inherently posits that the lump sum in the LG 2017 license, and indeed the lump sums in all of the other licenses with one exception, are not just slightly low, or whatever other expression might be used, or indeed a counterbalance, but massively below a true FRAND rate. And that is a proposition which the judge specifically rejects in these passages, not least in paragraph 726, which specifically holds that there is no evidence that they imply rates far below the true value of InterDigital's portfolio. Now, Mr. Speck said in his oral submission that this passage is concerned only with an entirely separate argument about holdout and has nothing to do with discounts for past sales. And we say that is wrong for a series of reasons. First of all, as I showed the court yesterday, the suggestion that the past sales issue was somehow divorced from the points about holdout and discounts overall is simply inaccurate in terms of how the case was actually presented, and I gave the references yesterday. Secondly, this passage in fact explicitly refers to the issue in relation to past sales at paragraph 728 to 729. Thirdly, and perhaps most fundamentally, this passage does deal with the central question of whether the Lenovo 7 can be taken to imply rates which are far below the true value of InterDigital's portfolio or not, and rejects InterDigital's case in that regard at paragraph 726. just as that same point was rejected in the specific context of each license. And fourthly, this passage is not the only passage confirming our analysis anyway. There is the consideration of each of the individual licenses and the findings that are made by the judge as to the inferences to be drawn about the lump sums therein. Slightly low, a counterbalance, upper bound, and such like. Yesterday, my Lord Justice Birss raised with me the question of whether all these findings I've been showing the court about the Lenovo 7 being the best indication of the true value of the portfolio are consistent with the judge's earlier, more general findings about a practice of heavy discounting for past sales. And as I submitted yesterday, we say that the findings about general practices in the industry are entirely consistent and reconcilable with the judge's findings about the specific comparables in issue, particularly when read in light of the judge's specific findings about InterDigital's own licensing practices. And my lords, there are a number of points that we make in this regard. The first point is that as regards a number of the licenses, past sales were not an issue. Most conspicuously, Samsung. Those licenses where there were no past sales in the analysis are a vital cross-check because there can be no suggestion of any inconsistency in that regard. In making the finding that the judge did about Samsung being slightly low, that was not based on any alleged depression with past sales. It can't have been because there wasn't any such issue. The price was found to be slightly low instead because of a completely standard issue in pricing of these licenses about the so-called coattail effect, as the court will have seen. That's the first point. The second point is that as a matter of approach, the court should not, in my submission, readily conclude that when making specific findings about the Lenovo 7 licenses, the judge had failed to bear in mind his own earlier findings about the industry or InterDigital in general. The ordinary approach is, of course, to consider the judgment as a whole, and as it happens, an analogous issue arose in the CSC case that we were looking at yesterday, my lords. It's in Authorities Volume 1. At page 335 in tab 16. And this was a case in which the High Court had found that the Copyright Tribunal had failed to bear in mind an earlier passage of its own reasoning, in this case in relation to its statement of the law. And at page 335, paragraph 71, the Court of Appeal said, to come to a different conclusion about the tribunal's reasoning would necessarily involve an assumption that the tribunal ignored its own statement of the proper legal approach in paragraphs 61 to 73. 72, it would be an unusual case to conclude that a specialist tribunal in a lengthy, conscientious and detailed judgment had ignored its own clear and proper statement of the correct legal approach. There may be rare cases in which an error is so clear that a conclusion to that effect is unavoidable. That is not the present case. So that's the ordinary approach is take the judgment as a whole. That's the second point on this. The third point is that the inference that this was a rare case where this had occurred is rendered even more unlikely by the fact that the judge himself referred to his findings in relation to the past sales issue in the very passage that I've just been showing the court, paragraphs 728 to 729. The judge, therefore, clearly did have his own earlier findings in mind here. In other words, whatever general practices there may have been in the industry, or indeed within InterDigital, the main Lenovo 7 licenses were not affected by them, or rendered non-FRAND by them. They were the best guide to the true value of the portfolio, as the judge found. That's the third point. The fourth point on this is that the judge's finding was that InterDigital had found ways to cope with the practice of demanding discounts for past sales. He said that at paragraph 729 in the passage we've been looking at.
Can I ask about that? Because, correct me if I'm wrong, but at the moment it seems to me what the judge found was that the way in which InterDigital coped with the problem was by inflating its future rates. But then he said the future rates were unacceptably high. So what do you say to the proposition that follows from the judge's reasoning that InterDigital were damned either way? They were damned if they didn't discount for the past, and they were damned if they responded to the past by inflating the future.
I think the answer to my Lord's question is that the rates, the judge's finding that the rates were inflated, apply if and to the extent that one seeks, as InterDigital asked this court to do, to use the future rates in isolation from the past rate, which is derived from whichever license you're talking about. If one is working with a fixed lump sum, which is FRAND, and if one assumes that the past rate is deflated to a non-FRAND extent, then as was canvassed in argument yesterday, what will be produced from the analysis as a matter of logic and reasoning is a future rate which is non-FRAND to an equivalent extent. Of course, for a particular licensee, it balances itself out because the lump sum is FRAND. So long as you do what Mr Meyer did and you take the past and future rates together, you'll be working on a FRAND basis. What is non-FRAND, and what clearly is inflated, is to take the future-only rate from a particular license and then apply it to the entirety of somebody else's sales without making the same allowance, because then by definition you end up with a lump sum which is in excess of FRAND. And indeed the judge was quite careful throughout the judgment in linking his views about the depression in recovery for past sales with the inflation of future rates. I won't go through it all again, but we have paragraphs 416, 443, 563 to 564, 619, and 729. And it's not just about taking the future rate. It would be just as unfair in the other direction to take the past rate and apply it without regard to the future rate. It's not a directional point, as it were. It applies in both directions.
As I understand it, Mr. Segan, what you're saying is that in the passages that we were just looking at, that we're referring to, 728 and 729, although to the incautious reader, like me perhaps, what the judge seems to be describing is an effect which is holdout, which means that the one party, happens to be the licensor in the holdout case, is not getting FRAND, but something less. You say, in fact, they are getting FRAND. The only thing that, in fact, to read these paragraphs as if this is about InterDigital actually being affected by holdout in any material way is wrong. They're not being affected by holdout. They're getting a FRAND rate.
Well, my Lord,
I've got to tell you, it doesn't read that way. Let's be absolutely blunt about it, Mr. Segan, but your submission is that this, although it appears to be saying that InterDigital is affected by holdout, in fact, they're not being affected by holdout. They're actually compensating so that they're still getting FRAND terms.
Well, my Lord, it is. Yes, it is. And I should, given my Lord's qualification, deal with the point that my Lord makes that that's not how he reads this passage. This this passage as a whole is entitled, "Were the 7 all the result of holdout?" This is page 180. And the passage as a whole considers that very question. And the judge makes a specific finding in 726. And I emphasise the point, it's not just 726, it's all those earlier findings on the specifics of the licenses that lead to this point. But the judge makes a finding in 726 that there is no evidence that the PLAs with the Lenovo 7 imply rates which are far below the true value of InterDigital's portfolio. And that is and can only be a finding that the lump sums were frowned.
So the upshot is this, that there's a finding by the judge that there's an industry-wide practice of heavy discounting for past sales. This is attributable to 2 factors, neither of which is frowned. One is that prior to Unwired Planet, the thinking was you had to sue territory by territory. 2, limitation periods. And he specifically holds that both of those factors have impacted InterDigital. And yet, despite all of that, InterDigital is apparently, on your submission, unaffected, because they still got what they were entitled to.
Well, my lord, the submission is that on his own findings, InterDigital had found ways to cope. And what is more, my lord, all the findings my lord is referring to are findings in the general section of the judgment about general practices in the industry. There is the additional complication that there is a complication arising from the word discount in the first place. Because as we know, discounts was being used in 2 senses here. Discounts was being used in the sense of something subjective, perceived by InterDigital, and which the judge found to be unreal, in fact, an ex post facto justification of a market value which had actually been achieved in the market. And then the other sense of a discount, which is a true departure from a frown rate. And the judge is finding, leaving aside those general findings, the judge then looks at these 6 or 7 licenses. In particular, he goes through the evidence. He had evidence on them.
Yeah, and you took us through them carefully yesterday. Thank you.
And my lord, the 5th... Sorry, my lord.
It's not quite as simple as what you said a moment ago, which is that when you've got to 726, it must follow the overall rate is frowned. Because he goes on in 727 and says, well, I'm rejecting that extreme case. But there's still a question whether there might be a degree of holdout. And that's when he says, we've got the practice of discounting. So, but the question is, does it affect the rates? And as I read it, he ends up by saying, well, I don't really know. The evidence didn't really take me there because nobody was running a middle case. What do we do with that? I mean, I think if one reads from 727 all the way through to 734, I think he thinks there might be a degree of depression of the overall rate through these 2 obstacles which is identified in 728, but he's given no assistance as to what it might be. I suppose that's his finding. What do we do with it?
Well, my lord, if that is his finding, given that it was InterDigital's case to make that these licenses included some quantifiable, non-frowned depression.
Surely it's both parties' case to establish what a frown rate is.
Well,
is there a burden of proof issue here?
I'm not sure it's quite a...
I mean, if anything, the burden of proof is on you, isn't it? Because you're the party seeking the defence to the claim for infringement.
Well, my lord, in a valuation case, it's probably quite difficult to analyse, but our case certainly was, these 7 licences have been concluded between willing licensors and licensees in the market. They're the best evidence of the frown rate.
And he accepts they're the best evidence
and that's,
that there is.
Indeed. The riposte to that from InterDigital was to say, no, that's wrong. And the reality is, the reality of the case in terms of the way it was actually presented, was that the attack was a discounts case as a whole, as I've shown you, in which there were a multitude of alleged discounts which were said to have been given, amounting collectively to billions of dollars.
That's what he calls the jackpot case, and that he has clearly rejected. But he does leave open the possibility that these rates might be a bit high.
Well, and my lord, there are a number of responses.
Or a bit low.
Yes.
A bit low.
Yes. So first of all, the judge, well, this actually brings me to the fifth of the points I was going to make on this inconsistency issue, which is this. If one wants to test empirically the issue, look at the rates in the field graph and the rates that you get from the licenses where there were no past sales at all. Because if there were a significant depression in the lump sums, which is a critical issue here, the lump sums for the licenses where there was a past sales element, one would expect to be seeing those licenses producing per unit rates that were appreciably lower than the licenses where the license covered no past sales at all. That is what one would expect to be seeing. And instead what one sees from the graph is in fact precisely what the judge describes here. Because what one sees from the graph is that even where there were past sales, InterDigital has in fact achieved a per unit rate, even for those licenses where there were past sales, which is broadly consistent with the rate that it derives from licenses where there were no past sales. And that is strong empirical support for the judge's finding that the lump sums are not non-frowned. That they are indeed the true value of the portfolio. We say InterDigital is a license.
Doesn't the point work completely against you? Because isn't Samsung 2014 a bit low, which is exactly what you'd expect if there was a bit of depression?
No, my lord.
It's the other way around, isn't it?
Yes.
Okay. That's fine. It's a bit low, so you'd say that's the opposite. I get it.
That it is indeed. That's what one would expect to be seeing. You would expect to see, here's a license which has no past sales. The rate is X. For those licenses where there were past sales, if there had actually been an impact of past sales discounts on the lump sum, which is the key issue here, one would expect the per unit rates for those licenses, for LG 2017, for Xiaomi 2021 and the like, to be appreciably lower. And they are not. And we know that that cannot be explained. That cannot be explained by volume discounts, because the judge has found in findings that are not appealed that there is simply no economic justification for them, and they are an ex post facto rationalisation. None of the passages, what it comes to is this, none of the passages relied upon by Mr. Speck begin to warrant an inference in the face of all of the findings that I have shown you, that the LG 2017 licence, all the rest of the Lenovo 7, were concluded for lump sums hundreds of millions of dollars below the Fran rate. That is a proposition that the judge rejected. And there is no evidence to support it. My lord, I should, in this context, address briefly Mr. Speck's reliance on the schedule in Bundle E, showing LG's last negotiating position. My lords will recall that. Now, that is a rather extreme example of island hopping, because we have no context whatsoever as to how that statement came to be made by LG, what suggestion or communication it was responding to. We haven't seen any documents, and there was no fact evidence on this issue. But perhaps most importantly, The evidence and the judge's finding is that licensees do not care how the lump sum is allocated between future and past sales. That's paragraphs 147 and 779, subparagraph 3 of the judgment. They just care about the lump sum. It makes no difference to LG how InterDigital chooses to rationalise the lump sum it's going to be charged. What LG cares about.
Well, I don't think it's in dispute that all licensees care about at the end of the day is the lump sum. Licensors may be in a different position, they may not. But let's concentrate on the licensees. But would you dispute, and if you do dispute, do you say the judge made any finding, that in negotiations it may suit a licensee just as much as a licensor to split it up into past and to future and to argue about both aspects?
Well, in fact, my lord, the judge goes slightly further because he quotes a passage, and I'll be given the reference, he quotes a passage from Mr Javaharian, where Mr Javaharian pointed out that in fact the incentive sometimes goes even further, because once one has reached a measure of consensus on the lump sum, because all these implementers are competing with each other, it is actually sometimes, well, usually in the interest of the implementer to assist in producing a license which produces an implied future rate which is high, because they know that that's what then will get quoted against other implementers taking a license under the same portfolio. Now, I'll get the reference for that, but that was the evidence.
Fine.
Your point is, it doesn't matter to the licensee how you split it up. What they're interested in is the overall money. It does matter to the licensor because it enables them to say they've got a headline rate and that's the future rate. And the point you've just made is that can suit the licensee as well. So it's not surprising if that's how the licensor wants to negotiate. So if the licensee says, okay, well, I'll negotiate your X% down to Y%.
It makes
So
no
I
odds
must say,
to
Mr.
them.
Segan, I'm not sure I buy that, because at least in this market, most of the time, someone who's a licensee today probably will want a license again in the future, because the products are sold for longer than the terms of these licenses, which means that if a licensee has agreed what is in the first license a future rate, which is very high, then they know perfectly well that the next thing that happens when the licensor comes calling on the day, well, actually the day before the first license expires, the licensor will point to the future, what was then a future rate, and say, well, you were paying that, so you'll have that, thank you very much. So I really don't believe it's as
And there's
simple as
plenty
you're
of findings about that in the judgment, because most of these licenses only run for 5-6 years, and then there's renewal negotiations, and that's why we have Samsung 2014, that was a renewal. We've got Huawei 2020, which is a renewal, and so on.
Well, my lord, if one wants, my lord's question, I think, was, what, if I'm accurately recollecting, I could go back to it, but it was, did the judge make any findings on this, and if so, what was the evidence? The judge's findings on this are the ones I've already mentioned, at paragraphs 147 and 779, subparagraph 3, that the licensees don't care one way or the other. In relation to the evidence that was from the licensing professionals, as I said, there was evidence to the effect I've described. I don't need to go that far. It's a matter, ultimately, interests may differ. They may reconcile, they may reach a provisional agreement, they may not. But the whole rationale of the comparables approach, as I identified yesterday, is to focus on what was actually agreed in the license agreement for good reason.
Yeah, well, that's the only thing that's certain for sure.
And my lord, the point that the judge, that I've already made, that the judge found the lump sums to be Frand, is confirmed by what the judge said in his form of order judgment. This is core bundle, tab 3. at page 262, paragraph 117, the judge refers to the point in the second sentence. It is said I erred in adopting the blended rate and should have taken the future rate of 61 cents. That is then addressed, paragraph 121 at page 265. And the judge identifies two separate issues, the first being whether the court should be bound by justifications internal to InterDigital. And the second is fourth line. On that basis, the alleged error is that I adopted a solution which did not take any account of past discounting or waiving at all. 2 points arise. The first is, this allegation is founded on the assumption that the lump sum agreed in LG 2017 was not FRAND, or in the FRAND range. This assumption is a challenge to my evaluation that the lump sum in LG 2017 was FRAND. And then secondly, he makes the point that my Lord Justice Nugee has already referred to, that InterDigital didn't develop a case in the middle ground. I shan't go through all of it, but paragraph 125, page 266, on that same point about the middle ground, the judge says, let me assume for the purposes of argument that the lump sum in the LG 2017 was depressed somewhat, whether by holdout or some other factors. I can see no possible basis upon which it could be maintained that but for the holdout or other factors, the derived per unit rate could be 61 cents. My Lord, that was the first of our 8 reasons. The second is that ground A is inconsistent with the rates which one can derive from the Lenovo 7. We deal with that in paragraphs 56 to 57 of our skeleton. Yesterday, my Lord Justice Arnold asked me whether we advanced a case that the rate settled by the judge could be supported by other licenses, even if LG 2017 were found to be rejected or undermined for some reason. I confirm that we do indeed advance that case. And indeed, we submit that the rate settled by the judge is already amply supported by his own reasons.
Well, can I just ask a question, since you reminded me of that question? The hypothesis is, and obviously this is just a hypothesis at this stage, that the judge, having taken LG 2017 as the comparable upon which he bases analysis, and it is assumed that his analysis based on LG 2017 is flawed. And what you've just told me is that your case is that even upon those assumptions, you say his conclusion based on the other licenses in the Lenovo 7, his conclusion can be supported by those other licenses. But do you have a respondent's notice to that effect?
Yes, my Lord.
Excellent. Show me that.
Core bundle, tab 6, page 300. Next, the first hole punch on page 351. For the avoidance of doubt, Lenovo's position is that even if the appellants are correct, which is denied, to assert that the judge incorrectly relied on a single license as a suitable comparator in deciding the appropriate FRAND rate, the court would in any event have still identified a rate in the range of 17.5 cents per device, which is ultimately found to be FRAND based on the proper unpacking of the most pertinent basket of comparables, the Lenovo 7. My Lord, we say that that notice is, strictly speaking, unnecessary anyway, because, as I've pointed out, the judge found that the Lenovo 7 were the best group of indicators of value of the portfolio. Paragraphs 611 and 726. And what is more, when reaching his assessment based on LG 2017, as I showed you yesterday, the judge explicitly had regard to where the lump sum sat per unit when compared with the rest of the Lenovo 7. And my lords, in that regard, we saw, for instance, paragraphs 795 to 799, 805, 809. My lords may recall, for instance, paragraphs 795 to 796, where the judge identified an initial bracket based on Samsung 2014 and Huawei 2016, one of which was slightly low and the other of which was a counterbalance. And it is true, of course, that when settling the final FRAND rate, the judge ultimately relied on the LG 2017 license to obtain his precise number, and found that the others didn't assist him in that regard because they were more different from Lenovo than LG. His analysis of how to get to LG, and indeed to the number to be derived from LG, is rooted in the other licenses and in the rates to be derived therefrom. Indeed, when in fact determining the rate of 17.5 cents in paragraph 813 of the judgment, the judge refers explicitly to it reflecting all of the considerations I have discussed above. My lords, we set out in a table at paragraph 40 of our skeleton argument, core bundle tab 7, page 373, of the per unit rates pre-adjustment, which were derived by Mr. Meyer for each of the Lenovo 7, and we give the judgment references. In some cases, those figures were specifically endorsed by the judge. That's Apple 2016, LG 2017, and Xiaomi 2021. But more generally, the judge generally preferred Mr. Meyer's figures, as we will have seen, as more reliable, for instance, at paragraph 623. And indeed, it's Mr. Meyer's figures that are used later in the judgment when comparing the various licenses at paragraph 796 to 798. And importantly, the first three of the licenses on this list, at paragraph 40, did not include any past sales in the analysis at all on Mr. Meyer's approach. There's the complication with Apple that we discussed yesterday. But the first, Samsung 2014, did not even have any appreciable past sales at all. We've given a graph of those rates at paragraph 56. And at paragraph 57, we set out a summary of the judge's findings as to where the rate in question sat in relation to FRAND.
This seems to be a repetition of the point you've made forcibly about 10 times now, that InterDigital's case on the appeal can't be reconciled with what the judge has found in terms of the applicable rates. Because you can't, you say, and you've said it, as I say, I think about 10 times so far, you can't possibly justify many multiples. And here you just give a chapter and verse on the multiples.
In which case, my lords,
I think we've got the point.
With gratitude, I can move to the third of my 8 points, which is the failure to develop a moderate or sensible middle ground figure, which attempted, in fact, to quantify whatever allegedly non-FRAND element lay in the lump sums in those of the Lenovo 7 licenses which contained a release.
Yeah, and this is based on the passage that you just took us through. And I think we all see the force of the point that the judge makes, and you support, that InterDigital were running, and you say are still running, a jackpot case case with no middle ground. But I come back to the question I asked you before, because although you made some submissions which I understand about on that topic, I wasn't quite clear as to your answer to the question I actually asked, which is this: where do you say the burden of proof lies?
On this specific issue?
On this specific
On
issue.
this specific issue, my submission would be that the burden very clearly lay on InterDigital.
Why?
Because this was their argument. Their argument was that the lump sums in their own licenses could be taken to be non-FRAND because there was a substantial discount for past sales. That was their case to make, my lord. We established, by reference to valuation evidence, by reference to the documentary evidence in the case, by reference to the witness evidence in the case, the position that there were lump sums, that they were agreed between willing licensors and licensees, and indeed the judge accepted ultimately that they were FRAND. If my learned friend wanted to show that in fact in these licenses there was some element that was non-FRAND, that was something for him to show.
Right, okay. What would you say to an argument on the following lines? Because I think this is maybe part of the way Mr Speck puts it, which is that on the issue of fact, the burden was on InterDigital, but they prevailed on that issue. They established as a fact that there was heavy discounting for past sales, and they established as a fact that it was attributable to non-FRAND factors. What they failed to do on your submission and on the judge's analysis is to establish the proper quantification of that.
Well, my lord, there are two layers of answer.
And
sorry,
is it your submission that they bore the burden not only to establish the facts, but to establish the proper quantification?
I have two layers of answer to my lord's question. The first is this: it was not established as a fact that these lump sums contained appreciable discounts for past sales, let alone that any such discounts were non-FRAND discounts, i.e. true discounts from a FRAND rate. To the contrary, based on all the findings I've shown the court, the judge found the opposite. That's the first layer of answer, but the second layer of answer is this: if and insofar as InterDigital wished to show that there was an appreciable or substantial or material impact, then it was for InterDigital to quantify that. He who asserts must prove. And the reason this matters, my lord, I do say one needs to step back here. This was a very large piece of litigation. It was years in the preparation before the FRAND trial. InterDigital chose, throughout that entire process, as I showed the court, to advance a case, its only pleaded case, that the only probative licenses were those with extremely small licensees who bore no relationship to Lenovo.
Yeah, well, as you pointed out, that failed dismally. But
Quite
as is recorded in the judgment and you've acknowledged, they also relied in the alternative upon LG 2017. And, of course, the judge didn't accept their case on LG 2017, but nevertheless, they did advance a case upon that basis.
Indeed, my lord. And what happened was, in an attempt to explain away the lump sums that they had actually agreed with pretty much the entire industry, 98% of their units under license in the Lenovo 7, a case was run that there had been these huge discounts. Now, as regards past sales, the only suggestion that was ever offered by InterDigital as a way of allegedly dealing with the problem that they identified was to ignore the past sales altogether.
Yeah, well, I understand all of that, but what I'm struggling with is I don't quite understand what your answer is to the point that I was trying to make earlier, which is that, first of all, this is your defence. Secondly, when it comes to comparables, you were asserting that the Lenovo 7 were the best comparables. So that was your case. And it was therefore your case to make that A, they were comparable, and the extent to which they weren't comparable, what the appropriate adjustments were. So why wasn't the burden equally on you?
My lord, in fact, obviously I go back to the fact that as a matter of fact, we did establish that they were comparable and the judge did accept that the lump sums were flat.
Right.
The contention that they contained appreciable discounts for past sales, if and insofar as they dealt with past sales at all, which of course not all of them did, but if and insofar as they did deal with past sales at all, those rates were discounted, was a contention advanced by InterDigital. That wasn't our case. Ultimately, that was their case, and the only way they offered the judge of dealing with it was to ignore the past sales altogether. And having looked at all of the evidence and at the rates, the judge found that doing so gave you a distorted picture of the true economics of the agreement and gave you inflated future-only rates, as we know. And the problem, as argument has indicated, the problem is a fundamental one, because if you're starting with a fixed lump sum as the unit of the analysis, and if you assume that the past has been deflated to some extent to reflect a non-Fran factor, then as night follows day, what will happen is you produce a future rate which is inflated to a corresponding non-Fran extent.
Yeah.
And that problem gets worse the larger the proportion of past sales that are contained within a licence in question. And my lords...
Yeah, well, that point I think we do have.
And it is, my lord, it is notable in my submission. On day one, Mr Speck handed you up some worked examples. And those worked examples are all start from the premise that the licensor and the licensee have agreed a rate of $1, which is Fran, and a discounted rate of 10 cents. And of course, on all the evidence, that is simply not what happens. Simply not what happens.
Would you accept that if that is what a licensor and licensee agreed, then the consequences follow? And they do seem to be just a matter of straightforward math.
I think, subject, my lord, to your lordship's HMRC point, as it were, even if parties in an agreement had decided actually to embody in the written agreement a rate of $1 for future rates and 10 cents for past rates, that would not bind the cause. It wouldn't bind a valuation expert in analysing the licence, and they might conclude, as HMRC might conclude, that that wasn't actually a reliable apportionment.
Yes.
But we are some way away from that, because what we have here are lump sums. And as I said, my lords have the point about the corresponding inflation in the future effect. And in fact, that's a point that the judge specifically made, that you get corresponding the inflated future rates. He made that point at paragraph 443. It's a point that he actually made specifically in the context of the rates from the LG license at paragraph 618 to 619. InterDigital could have developed a case to the effect that the lump sums were depressed by a particular amount or proportion because of an allegedly non-Fran depression in past sales, but it simply didn't do so as the judge recorded. And in those circumstances, we say the judge was fully entitled to conclude, as he did, that if there was any non-Fran factor baked into the Lenovo 7 which had past releases, he had simply been given no moderate or sensible factual or expert analysis attempting to quantify it. My lords, that brings me to the fourth reason, which is inconsistency with the evidence of Mr Mellor, paragraph 63 to 64 of our skeleton. The starting point here is that the judge did generally prefer the evidence of Mr Mellor to that of Mr Besant. We've given you the references at paragraph 35 of our skeleton. It's not just the bits on general credibility and veracity. Throughout the unpacking analysis, the judge largely preferred Mr Mellor's analysis, for instance, paragraphs 317 and 376 to 377. And that, of course, was a preference based on having seen the experts cross-examined respectively for a total of 4 days. That is important because, as we observe in our skeleton, the case being made by InterDigital in this appeal is contrary to one of the central parts of Mr Mellor's opinions, namely that the representative rates to use were the blended rates. My lords, if one goes, for instance, to paragraph 404 of the judgment, page 117, line 4, we see Mr Mellor's preference was for a royalty rate blended across past and future. In other words, applying the same rate to past sales as in the future, so splitting consideration between past and future is not necessary. That same point is recorded at paragraphs 421.
So, Mr. Tegan, would genuinely like to understand what exactly is it that Mr Mellor is giving admissible evidence about, which is being preferred? I mean, he clearly had that opinion, I'm not doubting that, but what is it about his opinion which makes it admissible? In other words, is it a matter for him? And by the way, this isn't a rhetorical, I don't think it's a matter for him, I want you to have a chance to say something. I really would actually genuinely like to know whether it's...
I think there are two questions probably wrapped up in my lord's question. The second of which I think I can deal with first, which is it a matter for the expert or is it ultimately for the court? And obviously the answer to that is it's ultimately a question for the court.
Okay.
We accept that. The first question is what's admissible from a valuation expert? And in fact, both valuation experts gave opinions on the question of reliability, the question of whether a particular method of extracting a number from a license was or wasn't reliable. And that is the camp into which this category of evidence, in fact, fell. Because, as we shall be seeing, I'll take you to his evidence in a moment, Mr Mellor's view was that the future-only rates gave you a rate which was artificial and inflated. And let me show the court, I've given you the references to the judgment, 421, 449, and 778. If we go to Mr Mellor's second report, bundle C, tab 14, page 508. Sorry, page 567. We see paragraph 20 summarises, this is a response to Mr Besant, the assumptions and inputs used to determine each of the three royalty rate calculations. And the table is headed Summary of Bazant 1 Assumptions and Inputs that lead to inflated effective royalty rate calculations, conclusions. The second of which is ignores releases of past sales, and that's dealt with in section 3. Section 3 starts at page 569. And at paragraph 27, page 571, Mr. Meyer sets out his principled reason for rejecting the approach of removing past sales, namely that the goal of a market comparables valuation cannot be achieved by simply accepting one party's view that various comparable transactions were discounted and the such like. But it's not just that. That's his principal basis. The same point arises at paragraph 31, that the methodology strays from the core valuation exercise that seeks to understand how much is actually paid per device. But the judge then considers what Mr. Meyer then considers what the effects of this are in practical terms of simply ignoring the past. That's paragraphs 34 and 35. And in 34 he says, I am not endorsing the use of these figures, but rather demonstrating the dramatic increases in the presented rates, which are directly attributable. And then he presents what happens on Mr. Bazant's analysis if you just ignore the past altogether.
This is very largely about volume. It's not, I mean, as you say, one of the discounts that's being discussed is past. But as one can see from the context in each of what he says at 35, a lot of this is about volume.
At this stage, my lord, yes. However, one can see, if one looks at PV adjusted consideration, between A and D, it goes up quite appreciably. So the effect of Mr. Bazant's analysis was to inflate the consideration and to decrease very significantly the sales volumes that were then used to divide that up.
Can you just explain to me, how is this helping us? Because we know, because the judge has found, that Mr. Meyer's preference was the blended rate. We also know, because the judge has found, that the fundamental reason for that was perfectly straightforward, namely Mr. Meyer's opinion that that was the best reflection of the economics of the deal, because it was the best reflection of what was actually paid. I mean, do we get anything more out of this than that?
Yes, my lord. If one then goes to paragraph 43 at page 580, in the next 3 paragraphs, Mr. Meyer deals expressly with the issue of removing past sales. And he says in 43, second line, that it results in artificially high rates which do not actually accurately reflect what was actually agreed upon. And I shan't read the whole thing out, but that's the effect of what he's saying. If you exclude the past, you get artificially inflated future rates, artificially high. Now, I am not suggesting, as was attributed to me, or more accurately, to this side of the court in general, that the court was in any way bound by these views. Clearly, it was an issue for the court ultimately to decide. But it is, we say, a striking feature of this appeal, at the heart of which lies the figure of 61 cents, which is extracted from Mr. Meyer's report. That InterDigital is asking this court to use a rate derived from Mr. Meyer's analysis in a way and for a purpose which Mr. Meyer specifically opined would be wrong and misleading, and would result in an inflated and artificial rate. That is what this court is being asked to do. Now, in my submission, even a first instance court would need to hesitate long and hard before taking that approach. But for this court to do that, having not seen or heard any of the evidence, and when the judge made findings agreeing with that evidence, would, in our submission, be quite extraordinary for all of the reasons I have explained. The fifth reason is the obverse of the previous reason, a bit like the past and future rates. It's that ignoring the past was the analysis of Mr. Besant. Mr. Besant was the only witness who proposed simply eliminating all past sales from the analysis, and that was a fundamental dividing line between Mr. Besant and Mr. Meyer. Mr. Besant's reports totaled nearly 1,000 pages, my lords, and I well remember the Christmas of 2021 digesting them. The first and second reports aren't even in your lordship's bundles. And the court is nevertheless being asked by this appeal to resurrect a central feature of Mr. Besant's analysis without having even looked at any of his reports, let alone having heard or seen him be cross-examined for 2 days. That's the fifth reason. The sixth reason is the consistency of the judge's approach with TCL and Ericsson. My lords, the setting of FRAND licence terms is an endeavour with global implications, as the judge recognised. In his judgment at paragraph 166 at page 46 of the core bundle, the judge said the development of the correct approach to setting global FRAND terms is an international endeavour, and that during the trial before me there was rightly extensive reference to the case law in other jurisdictions, notably from the US and China. And my lords, the only foreign decision any of the parties could identify which had dealt with the issue about past sales was TCL and Ericsson. That is in volume 3 of the authorities bundle at
You set
tab
out the
43.
relevant quote in your skeleton, haven't you?
Yes, we do indeed, my lord. The
Paragraph
only
66 of your skeleton quotes the relevant passage.
Indeed, my lord. So the only decision anyone could unearth which had dealt with this issue globally considered the question of whether one should simply ignore past sales altogether, and decided that that would give you, as the judge found in our case, a misleading picture of the economics of the agreement in question. Now, my lords, as the judge noted and was well aware of at paragraph 252, subparagraph 1 of his judgment, this decision was set aside by the Federal Circuit on the basis that insofar as it had determined a release payment, that was in substance compensatory relief for past infringements and should have been determined by a jury rather than by a bench trial. But the judge was right to find at paragraph 253 that it remained useful. It's the only consideration by a foreign court of this issue. And the US experts were agreed that whilst not binding precedent, it remained useful as an indication of the US approach. That's Taffet 1, paragraph 40, Contreras 2, footnote 13, and Taffet 2, footnote 2. And it may be noted that the UK Supreme Court also referred to and relied upon the decision on the non-discrimination point, the decision in TCL after the Federal Circuit appeal had already been delivered. That's paragraph 119 of Unwide Planet. My lords, Mr Speck's answer to TCL was that it was different because the proposal was to ignore the past sales altogether, together with any consideration said to be attributable to them. But that is exactly what Mr Besant proposed. It's exactly what InterDigital is inviting this court to do. So it is squarely the point with which this court is concerned. The seventh reason we advance relates to the SEC filings. And we say that the fact that Mr Meyer used InterDigital's SEC filings to ascertain distinct past and future rates, and that Mr Bresky was not cross-examined on his evidence as to how the allocation was done, certainly did not constrain the judge to adopt a 61-cent rate from the LG 2017 license. Now, the judge's findings in relation to the SEC filings and the blended rate issue and the accuracy of the splits are at 423, paragraph 423, page 122. The judge at 43 says, I'm going to follow the same approach as in Unwired Planet and TCL, namely a blended rate approach. And he gives two cumulative reasons. The first of which is that he formed the impression that InterDigital retained significant room for manoeuvre in the way that they apportioned an overall LS consideration to a pass release, and therefore as to the sum they recognised in their financial reporting as attributable to a pass release or pass sales. And my lords, we say, when one looks at the evidence of Mr Bresky, the judge was fully entitled to reach that conclusion. The evidence of Mr Bresky is in bundle C at tab 1. At pages 5 to 6 under the heading Fixed Fee Agreement. And next to the first hole punch in the lower hole punch in paragraph 14, about halfway through the paragraph, Mr Bresky says, this means that when analysing the royalties under a dynamic fixed fee licence, we will utilise market reports, brackets, for example, IHS iSupply or Strategy Analytics and or licensee provided projections, among any other information we find relevant, to estimate the number of units. So that's number of units. He then says, and apply the applicable royalty rate the licensee would have paid under a running royalty agreement based on our programme rates at the time and any applicable discounts to those units. With the publication of our royalty terms on our website in 2020, the accounting treatment would apply the published rates less any applicable discounts which the licensee qualifies for.
What's a dynamic fixed fee license? Dynamic sounds like the opposite of fixed.
I can help you with that because I asked. It's one where the portfolio includes stuff that comes in later. So if you have a license for the portfolio of Dave or whatever, and they require some more patents,
I see.
it covers them as well.
Thank you.
Yes, and I think the point is explained in paragraph 13, line 3, whether our performance obligation grants ongoing access to a portfolio of technology over the license term, dynamic or not, static. And paragraph 16 is in red, but I obviously make the same points about the impact of the published rates, the discounts, and the such like. Now, those inputs are inputs which the judge, as we know, found at length not to be reflective of the economic reality of licensing discussions, to be ex post facto justifications for lump sums agreed in market transactions, and generally unreliable. So the whole methodology turns on feeding in assumptions from InterDigital about its program rates and discounts, which the judge found to be flawed. And that can have a very significant impact on the output, as indeed the Form 10K that we have in the bundle acknowledges, Bundle E, tab 13. Page 161. This is the bit under significant agreements dealing with how to apportion LG. And in the third paragraph, having described the methodology, fourth line, the 10K says, the development of a number of these inputs and assumptions in the models requires a significant amount of management judgment and is based upon a number of factors, including the assumed royalty rates, sales volumes, discount rate, and other relevant factors. Changes in any of a number of these assumptions could have had a substantial impact on the relative fair value assigned to each element for accounting purposes. These inputs and assumptions represent management's best estimates at the time of the transaction. Now, my lord, as I say, based on the description of the methodology, it takes into account assumptions that the judge himself found in unchallenged findings to be wholly unreliable. And in those circumstances, the judge was not merely entitled to find, as he did, that these splits were unreliable and produced future-only rates which appeared to be inflated, but it would have been illogical for him to reach any other such conclusion. My lords, this was fact evidence, and Lenovo took no issue with it as a matter of fact that this is what InterDigital does. It was no part of Lenovo's case to suggest that Mr Bresky was misrepresenting InterDigital's process. But when one looks at what that process was and puts it together with the judge's findings, he was clearly entitled to find that it produced splits that were unreliable and future rates that were inflated. The judge's other reason was at paragraph 426. On page 122, that in any event, a FRAND analysis should focus on the money which passed between licensee and licensor, and that FRAND is not concerned with and should not be affected by either one party's internal justification of the sum paid or received. My lords, again, we say that's perfectly justified as a matter of principle. It's obviously right that one party's assumptions can't govern the analysis of a FRAND license. These findings are not realistically open to challenge by my learned friend. And if that is right, together with all the judge's other associated findings, that the future-only rates produced by applying this split are inflated, then the very number that this court is being asked to use as the central component of the FRAND rate you are being asked to determine is unreliable and inflated on the basis of findings which we say can't realistically be assailed. That's the seventh point. The eighth is discrimination. My lords, in this regard, I need to take you very briefly to Unwired Planet in the Supreme Court, in the Joint Authorities bundle at tab 2. Sorry, volume 2, tab 27. And if the court would go please to page 794. At paragraph 105, the Supreme Court begins its consideration of the non-discrimination issue in Unwired Planet, and as the court may know, or certainly will be aware, the argument was, line 5, Huawei relies on the Samsung license entered into by Unwired Planet as a relevant comparator for the purpose of working out the FRAN license terms. The worldwide royalty rate under Samsung was much lower and hence much more favourable. And in essence, Huawei's argument was that that then should be used as a ceiling for non-discrimination purposes. And the Supreme Court, upholding my Lord Justice Birss and the Court of Appeal, found that that was wrong. And their reasoning can be seen, for instance, at paragraph 110, page 795. Mr Justice Birss accepted Unwired's second argument. He held that the non-discrimination element in the FRAND undertaking was general in nature rather than hard-edged. The undertaking did not require that royalty rates in the license on offer to Huawei should be fixed by reference to the royalty rates in the Samsung license. On this basis, the judge found that the worldwide license on offer to Huawei was on non-discriminatory terms. The Court of Appeal agreed. 112, this court upholds the judgment of Mr Justice Birss and the Court of Appeal on the second of Unwired Planet's arguments. They were right to find that the non-discrimination element in the FRAND undertaking is general and not hard-edged, and that there had been no breach of it. They then consider the interpretation. And at paragraph 114, second line, the non-discriminatory part of the relevant phrase gives colour to the whole and provides significant guidance as to its meaning. It provides focus and narrows down the scope for argument about what might count as fair or reasonable for these purposes in a given context. It indicates that the terms and conditions on offer should be such as are generally available as a fair market price for any market participant to reflect the true value of the SEPs on to which the license relates, and without adjustment depending on the individual characteristics of a particular market participant. Put another way, there is to be a single royalty price list available to all. My Lords, Unwired was a case where a single license, which had been found to be unrepresentative of the true value of the portfolio, was being used to drag down, or was being used in an attempt to drag down, the rate below a fair and reasonable value. And that failed. This case, by contrast, is a case in which there are 7 licenses, with most of Lenovo's major competitors, who comprise nearly 98% of the volumes under license, at rates which are plainly far lower than the 61 cents per unit on an unadjusted basis, or the 49 cents on an adjusted basis that my learned friend is asking this court to compel Lenovo to pay. The weighted average of the Lenovo 7 was 16 cents per unit, and the weighted average future-only rate indeed was only 20 cents per unit. By licensing those units, all of those units, most of the market, InterDigital has set a market rate. It's a point that the judge makes on a number of occasions, which ought to be generally available as a fair market price for any market participant, to use the language of paragraph 114 of the Supreme Court's judgment. To put matters another way, how could it be described as anything other than discriminatory to require Lenovo to pay 3 times more per unit if one compares the rate InterDigital is asking for with the blended, at the weighted average of the blended rates from the Lenovo 7, than its competitors have all been paying? in my submission, the only circumstance in which that conclusion might conceivably be avoidable is if there were evidence that somehow all of the Lenovo 7 have been concluded at non-Fran rates far below the true value of the portfolio, which would put you in a similar situation to what Huawei was trying to do with the Unwired Planet Samsung license in Unwired. But that is, as the court knows, a finding which InterDigital sought and which was specifically rejected on the evidence. Insofar as there has been discrimination in this case to date, the discrimination has taken place in relation to the small licensees who were in red at the far right of the field graph. So, my lords, we say adopting an unadjusted rate of 61 cents for Lenovo or an adjusted rate of 49 cents would clearly involve failing to extend the market rate, which ought generally to be available as a fair market price for any market participant, paragraph 114 of the Supreme Court. My lords, that's all I want to say on ground A, unless the court has any further questions.
No.
I'm most grateful. I move, therefore, to ground B. Ground B
So
arises...
this is only pursued if InterDigital succeed on ground A.
Yes, my lord.
So you need to assume for the purposes of your submissions you've lost on ground A.
Yeah, quite right, my lord. It only arises if ground A were to succeed. But we do say that even if ground A were to succeed to any extent, ground B should still fail. It relates, as we know, to Mr. Meyer's 3 economic adjustments designed to ascertain designed to enable appropriate economic adjustments. And the adjustments are listed at paragraph 735 of the judgment. The first was sales distribution by cellular standard. The second was sales distribution by geography relative to emerging markets. And the third was sales distribution by geography relevant to patent coverage. There was consideration in detail of those adjustments from paragraph 738 all the way through to paragraph 772. And ultimately, the judge concluded in paragraph 791 at page 195 under the heading My Assessment of Mr. Meyer's 3 Adjustments. His first point was, if adjustment 1 is applied, there is a degree of overlap in the application of adjustments 2 and 3 on top of adjustment 1. And second, Mr. Meyer's approach is in certain respects too crude because the adjustments are applied according to the duration of each of the Lenovo 7. So this was the timing point. Ultimately, having decided that there was a measure of overlap between the first and second adjustments, at paragraph 807 on page 198, the judge concluded that the most important adjustment is to reflect the split between developed and emerging markets. Overall, I decline to make any separate adjustment to reflect patent coverage. So that's, he's not making adjustment 3. But the judge then says, I will apply a single adjustment ratio of 0.728 to reflect all the differences between LG and Lenovo. Now that number was explicitly not employed to reflect only the second of Mr. Meyer's adjustment factors. The judge makes clear he's applying it to reflect all the differences between LG and Lenovo. And we say paragraph 807 is an exercise of overall judgment on a broad brush basis of the kind which a court is frequently driven to make in these sorts of analyses. It's an observation which has been made frequently by judges hearing these kinds of cases. It was made in the TCL case. I shan't go back to it, but it's volume 3, tab 43, page 1158.
In what way is 0.728 broad brush assessment?
My lord asks a very fair question. The number is clearly not. I couldn't say it is anything other than precise.
It might be characterised as spurious precision.
My lord might very, very well say that. If that had been an issue, no doubt it could have been discussed with Mr. Meyer. But he produced these numbers. 0.728 was the adjustment for the second one, but the judge ultimately adopts it as a proxy, not for just the second one, but as a proxy for all of the relevant differences between Lenovo and LG. And as I say, courts hearing these kinds of cases have often made the observation that at some point in the analysis, one frequently has to make those sorts of broad brush decisions. It was done in, as I say, the observation made in TCL. On my planet, my Lord Justice Birss, on occasion, had to make those sort of broad brush evaluations, paragraphs 374 to 377 and 463. There is no rate from Mr. Meyer's reports which could be substituted on a like-for-like basis with the number applied by the judge in paragraph 807 of his judgment. Precisely because it's an overall evaluative judgment based on all the evidence he has heard.
Well, I can understand the submission that given Mr. Meyer's approach, as you say, there's no rate that you can substitute on a like-for-like basis. But does it follow that even if you've, on this hypothesis, failed on ground A, that the court should make no adjustment at all?
Yes. Because, firstly because...
What's the logic of that?
Okay. First of all, because that's the evaluation that the judge made as to the appropriate adjustment to reflect all the differences between LG
But that was on
and
the
Lenovo.
premise that he was right on the issue that this court has concluded that he's wrong on.
Secondly, because my learned friend has only offered you the proposal that you should adopt Mr. Meyer's alternative figure for adjustment 2, which would be clearly wrong based on the judge's approach at paragraph 807.
Why? I mean, isn't the judge going through, he looks at adjustment 1, adjustment 2, and adjustment 3, and he makes the very points he makes, and then what he concludes is he will apply a single adjustment ratio, which is in fact the number for adjustment 2. That's what he does. Seems perfectly legitimate exercise, if I may say so. Whether I would have done it to 3 significant figures, I have serious doubt, but never mind. But he does that, and if the premise is that the starting point was wrong, why doesn't one apply precisely the same logic and conclude it's the other number for adjustment ratio 2?
The answer, my lord, is that in paragraph 807 he makes clear that he's not employing the adjustment ratio purely to reflect the considerations in adjustment 2, but rather as a proxy for all of the differences between LG and Lenovo, and in the absence of equivalent figure that can be substituted.
So is it your submission that the coincidence in the figures to 3 significant figures is a coincidence?
It's not a coincidence in the sense that that's the number that the judge has adopted, my lord.
Right.
But he has adopted it as a proxy for a far wider range of differences between the two parties than are being embodied in Mr Meyer's numbers for adjustment 2. That's the point. And in those circumstances, there, as I say, there is no equivalent figure in Mr Meyer's report that can be substituted on a like-for-like basis.
Where do we find in the evidence the figure of 0.728?
And that's the answer, my lord, is it's in Mr Meyer's schedules, which were submitted after the judge had reserved judgment, when he made his request for additional material, which is dealt with, I think, at paragraph 773 of judgment. Yes, 773. He asked,
Yes, he asked.
can I have some more information?
Yes.
And
Do we have them?
yes, and I can get, my lord, the reference, but I won't do it on my feed. They are in the bundle. But in terms of picking out where the 0.728 figure is, let me just see if I've got it flagged. This may be what I do have a recollection of hunting out the figure 0.728 in this bundle, but it may be that it's on case lines, my lord. I think we can get back to the court with that reference. I don't want to waste any more time in oral argument as I stand here. My lords, that's what we say on ground B. To return briefly, I've been reminded that in fact, in relation to ground A, on my Lord Justice Arnold's burden of proof point about ground A, I've been reminded, and it is potentially an important point, that in fact InterDigital did make a request for further information. Sorry, Lenovo did make a request for further information for details of what discounts had actually been applied in relation to each of the Lenovo 7 licenses. And the answer that came back from Mr. Grew in his second witness statement, which is analysed at paragraph 144 of the judgment, was that it wasn't possible to set page 40, paragraph 144.
And why is that relevant?
The answer is, my lord, at that point, how can one interrogate any further the question when InterDigital itself is saying, we don't know?
So the hypothesis, as I understand it, is that there being an industry-wide practice of heavy discounting for past sales, which is due to non-brand factors, and all of that having impacted on InterDigital. InterDigital is in some way supposed to have been able, at the time of executing each of these licenses, to have quantified the extent of that.
Not at the time of concluding the licenses, my lord.
No, that was the question. Lenovo requested a list of the discounts actually applied. That was the question.
Yeah, indeed, my lord. As part of the forensic process of preparation for trial, if it was going to be said that there was some specific element of the lump sum which was attributable to some non-Fran factor, notwithstanding the point that the evidence was that apparently one couldn't determine which discounts had actually been applied at all or not, then clearly that was a case for InterDigital to make.
Okay.
And my lord, there was fact evidence about the LG license, which of course was considered by the judge when he made all his findings about the LG license. I shan't take the court through it all, but it is after consideration of all of that fact evidence that the judge came to his conclusions that the lump, as he put it, the lump sum in the LG license is Fran. Yep. So, Lord, for all of those reasons, we submit that grounds A and B should be dismissed, and I pass over, subject, of course, to my lords, to Mr. Alexander to deal with the remainder.
Thank you very much.
Can I take C&D fairly briskly, as my friend Mr Speck did? As my lords are aware, there were two aspects originally to the top-down case. One of them was the hedonic regression, and the other one is the one that is still pursued. Both of them sought in different unjustified ways try and place values on generations of handsets and then attribute IDC's value. The hedonic regression found...
Again, for the purposes of this argument, this is only relied on by way of cross.
No,
So if Mr Speck fails on grounds A and B, this doesn't arise.
Yes, that's right.
So we assume that he's prevailed on grounds A and B. In which case, what's your answer?
Well, our answer is still it doesn't add anything. If anything, it detracts. And I'll try and explain to my lord on this.
Is that in your respondent's notice?
Well,
I don't think so.
It's not, but what it is it's a way of reinforcing the point that the judge was entitled to find all of this material entirely unreliable by way of a cross-check. Our starting point on this argument, as we've said in our skeleton, is that the judge found that both of these so-called cross-checks are not reliable, and essentially for the same underlying reasons, which is that they involve assumptions being made, which are unwarranted assumptions in this case, for a whole lot of reasons. And I won't weary my lord with the assumptions that underlay the debate on hedonic regression, but there were similar kinds of assumptions that were made in relation to valuation and so forth that underlay this aspect of the case. What IDC is inviting this court to do is to hold that the judge effectively was plainly wrong in the lifestyle, in the language of lifestyle and the other cases, in finding that a valuation approach which was so unreliable and inappropriate that it was not generally used in the industry, and he found that as a matter of fact, there was extensive evidence on this, that IDC itself had said should not be used, and IDC had not even deployed in a recent case before the Chancery Division, where it was seeking Fran royalties should be used as a cross-check, should nonetheless have been used, and as I detect my learned friend's argument, used as a way of deciding between two numbers, one the number that is put forward on this appeal, and the other the number that the judge held was the right number. The starting point for this whole argument is that the numbers, as my learned friend Mr. Segan has explained, that the judge reached were not uncross-checked. They were extensively cross-checked by reference to other real-life agreements, which the judge found to be of relevance and from which he selected the LG agreement as the best comparable. These were fully negotiated agreements over a significant period with significant undertakings in this field, and we've given the references to them.
Well, again, I see that point, but as you yourself said, that's a point that Mr. Segan has made repeatedly. I'm
not going to make that point again in in the context of the, as it were, the A and B appeal, but it does matter in the context of the C appeal, because if one is complaining that the judge did not deploy a particular cross-check, it is relevant to, for specifically the LG agreement, it is relevant to understand that the judge was deploying cross-checks by reference to that agreement, including in identifying its appropriateness in the first place. And the relevance of that, just in connection with the reliability or comparative reliability of those as a cross-check, comes from the evidence which the judge considered and which some of my lords will be familiar with, which comes from the process of these agreements being made. So the evidence was, and your lordship has seen that, it's in the evidence and reflected in the judgment, that typically when these agreements are negotiated, they start with a proud list and the parties making some evaluation of the portfolios, what might be called tire kicking on the portfolios. And then there are commercial discussions. What it's possible to do in the course of that kind of cross-checking, which then ultimately results in a number, is make evaluations of the portfolio that take account of things that no amount of patent counting studies could ever take account of, including things like whether or not the patents are likely to be valid, to some extent the contribution that they may make, the commercial value, and so forth. And that is why, if one is, as it were, choosing between cross-checks to use in relation to a given agreement that is identified as a prime comparable, one is obviously going to look primarily at other agreements of similar kind, where it is likely that that kind of analysis will have been possible in a way that's not otherwise. Secondly, of course, as the judge noted at the form of order hearing, the sum that he actually reached was itself cross-checked against IDC's own appraisal of its value of its portfolio and the value of the license, because your lordship will recall, and I referred to the document in tab E that we may come back to, it was IDC's case that it had won the case because it said that it had put forward a valuation of its portfolio which it said ought to have been accepted in November 2018. So the judge had a whole range of ways of cross-checking, which were in fact likely to be more reliable on one view, on this view, than any form of patent counting exercise. The second point is that there was a significant amount of evidence which pointed against the kind of patent counting exercise having utility in this case. We've referred to the fact that Mr. Peters, IDC's expert, didn't think that this kind of counting should be used for assessing the value of a portfolio at all, and we gave references to that in our skeleton. Now, I don't doubt that there may be some cases where, for example, you don't have a licensing track record at all, and there may be a very limited data to work on, but there may be some utility. But where you've got a range of established agreements, then no one was suggesting that this would be an appropriate basis for setting out value. We have put in our skeleton the references to our closing skeleton at paragraphs 156, with the quotes from those witnesses and the judge's conclusions in relation to that at the judgment at paragraph 836, where he summarises the position, and your lordships might like just to mark that as a summary of some of the material. Obviously, there's more that we've referred to in the bundles of why this kind of exercise in this context is unlikely to be of value at all. And one notes, of course, that Mr. Merritt, who was at that time the chief executive of Lenovo, IDC, effectively said that one shouldn't be using this kind of approach at all for valuation. And reasons were given by the licensing experts in this field, and that obviously reflects the approach that was taken by the United States courts as well, and indeed even the submissions that were made by InterDigital to the United States courts themselves, where they said and we agree with them on this, that real-world market outcomes are the most probative of value. Consequently, analyses of comparable licenses should be the preferred method of analysing frank terms, and resort to top-down and other patent analyses methods when comparable licenses are available is unwarranted, particularly in the light of the many sources of unreliability inherent in attempting to analyse the contributions of literally thousands of contributions to an industry standard. But we respectfully agree that in this kind of case, that is the right approach. So, in our respectful submission, for all of the reasons that were given, and we've added others, including the reference to real property valuations in Telereal and Trillium, and the Copyright Tribunal approaches, is that the judge was right to conclude that this was unlikely to be an approach that could ever assist, still less be a useful decider between two alternative approaches. May I just reinforce that very briefly, because it's not just that people were saying this, there are specific reasons why this kind of approach is not reliable. And we've drawn quite extensive attention to that. I don't want to repeat points that we made in our closing skeleton to the judge, but I'll just draw my Lord's attention to where they are so that you understand what the material was that the judge had to consider when he was reflecting the reliability or otherwise of this methodology. It's in Supplementary Bundle B, tab 5, at page 596 to 604, and we set out at length the issues on reliability, and if my lords are interested in the numerous reasons why an approach of this kind was not reliable in this case, we respectfully commend those passages to you, because what they do is actually highlight why, if I may put it like this, Mr. Merritt's observations about the approach are particularly apposite in this case. So if one takes just to take two of the multiple reasons, first in relation to patent counting and strength of portfolio, one of the sources of unreliability, and one that was specifically analysed by the judge, is that if one does patent counting without looking at the substance of what the patents actually involve, you can get very significantly inflated figures. And there was reference in the 3G analysis that I drew attention to on Tuesday about how, in the case specifically of InterDigital's portfolio, there was a significant element of duplication, indeed on one view, tenfold duplication. And my Lord Justice Arnold said, well, you can't tell whether the 6 or 60 remaining patents are any good, or what, summarise on that point. But in my respectful submission, if you're already faced with data that is of that poverty of quality, you're not dealing with a methodology which is very good at cross-checking anything at all. And the judge went on to explain and expand this point on this point in his form of order judgment, where he further explained why he didn't think this point had a merit. I don't think my lords need to turn that up. That is at form of order judgment, paragraph 141. And the point that he was making, though, was that it appeared to him that InterDigital had been playing what he described as a numbers game to push up the apparent share of standards essential patents. And where you have a position where you can see that a numbers game may be being played, it's obviously useless to use that kind of material, which is, as it were, inherently inflated, as a way of cross-checking whether or not a given number should be adopted. So there was a mass of evidence relating to that. I've already drawn attention to the fact that when this portfolio was originally asserted in the United States before the ITC, it foundered. So, and that is a indication of two things. First of all, that the numbers game just doesn't work. And secondly, that when one actually asserts patents, one actually has to look at the validity of them and see whether there's anything of substance. Similar position in the United Kingdom. Very significant proportion of the patents fell in a significant assertion program. The second point that we have made is it relates to what may be described as the aggregate royalty burden. That, as my lords know, is itself a significantly contentious number. My lords will know, and that there is evidence in Mr Meyer's statement of paragraph 127, that this whole issue of aggregate royalty burden was never introduced as a basis of valuation at all. What it was intended to be a cap so that people wouldn't have aggregate royalties that exceeded a particular level. It wasn't intended to say, well, you know, you're supposed to get to that level. And indeed, IDC had itself submitted an amicus brief that the lack of such a consensus was a reason not to use that as a basis for valuing portfolios in this case. Now,
Mr. Alexander, you've said basis for valuing quite often in these submissions. At least my understanding is that it's not being suggested that this is anything other than a cross-check. It's not the way in which you calculate the royalty. It's simply something, frankly, a fag packet, back of a cigarette packet envelope calculation to see what, in a very broad term, what this would imply.
well,
That isn't the same thing as many of the submissions you are, at least so it seems to me, fighting it with an Aunt Sally. And I'd be very interested to hear what you say about it as a cross-check, not as a valuation method.
I understand. Well, but what is the cross-check doing? It is cross-checking a valuation.
Yeah.
And so there has to be utility in the cross-check being used as a valuation method.
Just
as I understand my learning...
Give me just 1 second, Mr. Alexander. Just taking that submission to its extreme, I'm bound to say I would be surprised if, for example, one did the cross-check, simple mathematics, and it produced a number that was either enormous or like 0.001. One wouldn't say, that's interesting. That does rather suggest something's gone wrong, doesn't it?
You may be right, but let's suppose you've got a portfolio where you think, okay, well, actually, this may be 10 times overvalued because of numerical duplication. And the cross-check produces a number that is 10 times lower than the number that would be implied if the valuation was if notionally the portfolio was as good as the average, just to take a very crude calculation. You might say, well, actually what the cross-check has done in those circumstances is say, well, you've got a figure that doesn't sound wrong. Mm-hmm. Now, I'm not positively relying on that to say, okay, well, what the cross-check shows is that actually the figures that come out of this are the right figure on our approach. And part of the reason for that is because one can't really take the figures in the alleged cross-check and do that analysis. So but the utility of a cross-check very much depends on whether the number that comes out of the cross-check is a single number or one that has very significant error bounds. So let me take one example. Let's suppose that a cross-check yields a range. Now I'm talking as it were, purely theoretically here, a range, not necessarily even for this valuation, of 1 to 20. And the valuation on the basis of, let's say, conventional valuations yields a value of 2. So, well, actually, it's within the cross-check. Mm-hmm. And so the cross-check has essentially shown it's been of no assistance because you've got a very wide error bound in relation to the cross-check. And our point is that the cross-checks of this kind have such wide error bounds that the point that you're putting to me, I completely accept that point at the level that you put it to me, which is, oh, that is interesting, is not very interesting in this context. Because let's suppose that you reach the conclusion that the cross-check would yield 2 to 20. You say, well, okay, so I've got a value of 2, or conversely, a value of 18, or whatever the valuation may be. So, well, actually, it's within bounds. Mm-hmm. So, if one accepts that the value of a cross-check is to see whether something is within reasonable bounds, then in some senses this cross-check does it on the basis of the whole total unreliability of the data in the cross-check in the first place. And the point that I invite your lordships to consider is where you have a cross-check which you know is unreliable, because you can't do the basic numbers that you need to do in order for the cross-check to give you a given number against which you can cross-check something, then that cross-check is completely worthless, because it's not really doing anything other than saying the number could be reasonably within very wide bounds. And to that extent, a top-down cross-check can be of utility, because it can say, for example, well, if you're exceeding a very significant burden, then you might need to reevaluate it. What it can't tell you is going the other way as to whether you're lower. So I'm not sure whether that quite answers my Lord's question, but what it's intended to do is to explain why, in this circumstance, a cross-check is really not of any assistance. And to answer my Lord Justice Arnold's point in relation to, on the assumption that one's found one number rather than another from the rest of the case, if a cross-check has got very wide error bounds which encompass those numbers, as this indeed could, as the judge found that it on the basis of unreliability, then the cross-check doesn't actually add anything at all to the fundamental valuation exercise. So, in our respectful submission, just going back to the point on the fundamental numbers, there are a whole lot of numbers that go into all of these cross-checks, each of which involve assumptions that are either not plausible or are completely unproven from the facts of this case, or, if anything, the data before the judge would have suggested that the number that should come out of the cross-check would be a very much lower number. So, very briefly on InterDigital's other points, they say it's circular and illogical to reject a cross-check on the basis that the cross-check doesn't support the rate. Well, no, it's not circular or illogical. It would be wrong to use it in circumstances where one knew that the cross-check was unreliable. Indeed, what one would then be doing is taking something that was an unreliable number and using it to check a reliable number, which in our respectful submission would be a completely unwarranted exercise. But we don't understand their point that the judge's concerns that the simpler top-down used industry average ASPs and didn't take account of Lenovo's sales patterns was inconsistent with its approach to comparables. It wasn't, but it's a pretty minor point. They suggest that the reservations about the patent accounting studies were not open to him. How on earth can it not be open to someone to say, on the basis of all of the material that he has seen about the numbers, including the evidence that showed that taking the numbers were likely to be unreliable, was an unreliable basis for doing a cross-check? And our final point in relation to this is this. If one thinks about a finding of unreliability of a cross-check being itself a finding of multifactorial evaluation, then it would take this court to find that the judge was clearly wrong to reject a cross-check within the framework of the appellate function, in order for this court to consider that it would have been appropriate for the judge to deploy this cross-check in circumstances where it yielded results which were not the same as those of the valuation. And for all those reasons, we submit that there's really no substance in ground C. I can take, I think, ground D even more briskly and perhaps finish that this afternoon, if that would be convenient for my lords. In the light of the exchanges between the bench and Mr. Speck, I detect that my lords have the points. Very briefly, your lordships know that IDC was consistently seeking rates from Lenovo which were multiples above what was found. It was finding the judge. They refused to supply adequate information, and it wasn't just multiples above FRAND, it was completely outside the FRAND range. Their proposition as it's developed now seems to be that a patent owner can make even abusively high demands for many years, keep information from a licensee and others which would enable them to evaluate those demands, seek an order from the English court that it is not obliged to grant a FRAND license on the basis of a completely baseless case that the prospective licensee has itself behaved improperly, when in fact it's the licensor that has behaved improperly, a case which requires millions of pounds to be spent in defeating it, including extensive cross-examination of their witnesses showing that that case is a false one, and nonetheless come to this court and say that the discretion of the judge not to award a declaration declaring it to be a willing licensee was so improperly exercised as to result in the court interfering on that. I mean, one need only say that to realise that this is really a preposterous proposition. This case only arose because it was InterDigital who pleaded a case that we had lost our right to a FRAND licence.
Yeah, well, that's why we were questioning with Mr Speck what the utility of all of this is.
Indeed.
And can I just focus it by asking you this question? Assume that we accept that there is no utility in making a declaration that Lenovo was a willing licensor, which is what they're asking. Sorry, InterDigital, yes. Apologies, thanks to my lord for correcting me. So we don't think there's any utility in declaring that InterDigital was a willing licensor at all. Would you never, but also assume that InterDigital is successful in whole or in part on ground A? Would you resist or would you maintain the judge's finding of fact?
Oh, yes. I mean, but the answer is, I expect...
Even though it's very
Yes.
largely driven by his conclusion on the rate.
Well, there is a... I mean, my lord is right to put that point to me, because if there are actually two aspects here, one of which is essentially money-driven, rate-driven, and the other might be said to be conduct-driven. So if you conclude...
Well, but the point is, conduct's out of the window now, for the reasons that you were elaborating.
Indeed.
It's all history.
Indeed.
And that's just one reason, among others, why we may well conclude, I'm not saying we will, but it leads to the potential conclusion that there's no utility in making any declaration. However, what about the separate point that there's a finding of fact adverse to InterDigital, which is predicated upon a finding as to rate, which this court, on this hypothesis, concludes was wrong?
Well, on that hypothesis, one would need to work out, before thinking about a declaration, what findings of fact of the judge were overturned. Because on the assumption that my lord has put to me, there are quite a lot of findings of fact of the judge that would nonetheless remain in place, including on the other comparable licenses and so forth. Well, I actually can't envisage those remaining in place on my lord's hypothesis, but in any event, there are a number that remain in place. Our submission overall is that this is simply not terrain which is suited for declarations either way. One might say is that one's thinking about this in inquest terms. This is a case for a narrative verdict, I think is the right terminology. I'm not quite sure whether that's the right terminology. But the point that the judge made on the form of order hearing in relation to this issue was that there wasn't a declaration that could adequately encompass the series of findings that the judge had made. And we would respectfully submit that your lordships would be in exactly the same position. You would need to consider whether there was a simple formula that could reflect the extent to which you had...
Yes, but you're pushing it an open door, because the hypothesis that I'm putting to you is that we accept that there's no utility in a declaration.
Yes, yes. I understand, my lord. Then the question is, in a sense, how your lordships should draft your lordship's judgment.
Yes.
And we respectfully submit that in accordance with ordinary appellate...
And the reason being, of course,
that there's findings in the judge's judgment, even though he didn't make a declaration reflecting them.
I understand that. And the answer then probably would be, well, one would need to consider, once your lordships had made your judgment, whether any findings in your lordship's judgment could or should be reflected in a simple declaration on either side. Because the proposition my learned friend advances has a symmetrical counterpart, which is that if they were at all times reasonable licensors, then so were we on the same basis, because we were quite content, and I'll show my lord, draw my lord's attention to the approach that we were taking on this. And so what we don't want to have is a situation, which I think is what my learned friend really wants to have, is a kind of soundbite declaration. And I know that that's the point that, in a sense, your lordship is already on this hypothesis accepted, which they then take to a foreign court and say, look, the English Court of Appeal has held that we are willing licensors. Oh, but they haven't held that you, Lenovo, were willing licensees. So, German court or whatever, you should grant an immediate injunction in relation to us, or indeed others in the market. In our respectful submission,
I understand all of that, and I see the force of the point, but might that lead to the conclusion that the appropriate way forward on these hypotheses, and I emphasise on these hypotheses, would be for the court to say something along the lines of, it follows that everything that the judge said about conduct is academic.
it may be. What the precise formulation of that is would need to be the subject of some reflection. And part of the reason is this, what might be called the collateral use point, because what one doesn't want to have.
But you're concerned about collateral use, but so is Mr. Speck.
I understand.
And therefore, given that conduct has effectively dropped out of the picture, the neutral way of dealing is something along the lines I've suggested.
You may be right, and it may well be that this is a debate which, in some senses, ought not to be had right now.
Well, yeah.
in the light of my lord's, what my lord is putting to me,
yeah.
But maybe something that could be had when drafts of the decision are circulated. Because what it makes sense to do and say in this kind of context does depend on my lord's evaluation. And my lords may conclude, actually, either way, whether you uphold my client's position or otherwise, that you want to say something about the irrelevance of conduct in the history. And we're not going to be, I think, pushing on that position. But what we don't want to do is to have an asymmetric situation where essentially IDC's conduct, which we do really have difficulties with, is somehow sanitized by a declaration, which they are then able to use for their sort of litigation PR purposes in ways that are in fact inappropriate. And the reason I say that, and I don't want to be unduly critical, but Lenovo, IDC has mischaracterized our position on a number of occasions. Mr. Speck, before my lord, said, oh, you're just behaving like Huawei and possibly Apple in relation to this, in relation to our approach to the English court. We were not. We had a very sophisticated position based on the fact that there were two parallel proceedings which had rate a determining impact in existence at the time of the judgment.
Subject to the carve-outs, you accepted jurisdiction.
Indeed, we were saying, okay, there should be an undertaking, but it should be qualified so that you take into account, in accordance with what this court had said should be taken into account, namely the results of other jurisdictions. And it was my learned friends' clients who were resisting that. And if you want the references to that, that's at Bundle B, tab 5.
I mean, I understand.
Your lordships have got
again,
that
that's
point.
history now, isn't it?
It is to some extent history, but the reason I mention this is because this issue of mischaracterization is not just a theoretical one. It's IDC continuing to say that we're
We're
wrong.
sufficiently experienced to know that this always goes on with parties on both sides of the fence in all these disputes.
Yes.
PR is a very large part of it.
PR is a part of it. There are ways in which they've mischaracterised their position, and I might, in a sense, just leave it at this, which is that it may be useful just to reserve our position in relation to what the appropriate order should say in the light of the submissions that I've made as to the inappropriateness of pursuing matters in the way that InterDigital has suggested should be pursued.
Yeah, all right, that's clear, thank you.
Mr. Ellison, I have a question. I don't quite understand at the moment what a willing or an unwilling licensor is. I understand what an unwilling licensee is, but what's an unwilling licensor?
Well, let me give one example of an unwilling licensor.
I mean, I understand what someone who may be behaving badly. I get that. That I understand, and I understand the judge decided, putting it in my words, not his, that there were things to criticise about InterDigital's conduct. But what does it mean to say that they're not a willing licensor?
Well, I'm not going to attempt at this time in the afternoon to delineate all of the possible characteristics of an unwilling licensor, either in this country or elsewhere. But in my respectful... beg my Lord's pardon.
Stick with this country.
May I just stick with this country in this case? In our respectful submission, it is a characteristic of an unwilling licensor for someone to pursue an unjustifiably inflated licensing program over a long period of time, to attempt to secure license fees on that basis from others in the industry, when they resist that attempt, to say to this court that they shouldn't have a FRAND license at all as a result of their conduct justifiably resisting the attempts to impose a license on them. Because the notion of an unwilling licensor is one that involves someone who is unwilling to grant a license on FRAND terms. You have here a case where my learned friend's primary case here is that they should not have been obliged to grant a license on FRAND terms.
So you say a willingness to license at supra-FRAND rates doesn't make you a willing licensor at FRAND rates?
Correct. Nor does a willingness to obtain a license completely unconstrained by FRAND on the basis of what my learned friend described in his closing submissions to Mr Justice Mellor as a desire to obtain a plain vanilla injunction. That was his primary position before the judge, was a plain vanilla injunction, and that's in, wherever it is, it's in Bundle B at page 363. Now, if that's not the characteristic of an unwilling licensor, it's very difficult to see circumstances in which that concept would have any meaning. But then let's look at the symmetrical position. Let's suppose that I had said, my clients had said, well, we're not willing to take a license on anything other than derisory terms. Would that make me a willing licensee on the basis that someone who acted in the way that Lenovo, that IDC has acted, was a willing licensor? We respectfully submit that my Lord's question actually goes to the heart of one of the real difficulties in this jurisdiction, goes back to the difficulties with which my Lord has grappled now for over 10 years, that the Court of Justice has grappled with in Huawei and ZTE, that the Orange Book and so forth are grappled with, that the European Commission are grappling with as to this concept of willingness and otherwise. Willingness is relative to a willingness to grant a license on FRAND terms. And in our respectful submission, this is a case where one can see on the whole picture of the evidence that IDC was not such an undertaking.
Okay, thank you.
Unless I can assist your lordships further on those points, perhaps I can crisply deal with the cross appeal tomorrow.
Sorry, can I just go back on this question of why does it matter whether you're a willing licensor or not? I can see why it matters if you're a willing licensee or not. Because a licensee always has the option of saying, I haven't given any undertaking to Etsy. I don't have to take a license, and if the determination is, if I don't want to, I can leave the market. Maybe commercially impossible, but the licensor does want to be paid for the use of his patents. Why does it matter? Where does the concept of willing licensor add to the concept of what a hypothetical willing licensor would agree, which gives you the Fran rate. In just the same way, if you're trying to find the market value of rental value of rented property, you postulate a hypothetical landlord. It doesn't matter what the actual landlord is. He only gets what a hypothetical landlord would stipulate. So why does it matter whether the licensor is willing?
There are two answers to that question, and if I may answer them in reverse order. One relating to the concept of willing licensor, willing licensee, which where your lordship presents an analogy with a landlord-tenant situation. For that purpose, what you're trying to do is identify the notional willing licensor and the willing licensee. So to that extent, it is a legal concept, and is of importance to that extent, just to identify what you're talking about, which is what is the value of the demised property, or whatever the position may be. So that has its legal context. The second reason is because it may matter, and particularly matters in jurisdictions which are not as sophisticated as this jurisdiction, if I may put it like this. There are some jurisdictions where if the court says that you are an unwilling licensor, then you may not be entitled to given relief. Equally, if the court finds that you're an unwilling licensee, you may not be entitled to certain relief. And not every court is as on top of things, if I may put it like this, as this court. If you come at this with a perspective of, as I said, the copyright tribunal mentality, or licensing, a rate-setting tribunal as a mentality, so why am I even talking about conduct here? I would have thought would be the natural. How on earth can that matter? What I'm concerned with is what the valuation is at the end of the day.
Exactly.
That was the question.
And for someone outside the patent field, they would look at us with complete incredulity. On the other hand, if you go to certain courts around the world, and there is a finding that someone is either a willing or unwilling licensor, or willing or unwilling licensee, which may itself be based in part on their evaluation of the value. So let's suppose that a licensor comes along and says, oh, well, I think this is worth the moon. And the licensee comes along and says, I think it's worth threepence halfpenny. You could envisage a certain court saying, well, actually, you're not a willing licensor on the basis that you're asking for the moon. That's plainly unreasonable. You're not a willing licensee on the basis that threepence halfpenny is far too little. In English court, one would say, I'm not interested in this. This is just your pleaded case. Moon, threepence halfpenny, it's somewhere in the middle. Not so elsewhere, because if you're not a willing licensee, you can be subject to an injunction in some countries. So if it said, okay, well, you're a willing licensor on the basis that you've put forward something that looks Fran. So let's take this kind of case. A licensor can come along and say, oh, I've got all these minnow agreements. Look, I've got 20 agreements. Everyone has signed up for rate X. Look how willing, you can see how willing I am. Look at all of these agreements. You, licensee, why are you not signing up at this rate? Licensee says, well, that's not a reason. You're unwilling. What happens? You're not entitled to a Fran license at all, on any terms in some contexts. So that's why what I've described as the licensing PR matters. And it may matter for my learned friends, it may matter greatly for me and indeed others in the industry. And why, if I may respectfully say so, I detect Lord Justice Arnold asking questions about what might be called drafting rather than pure substance in this case. But the underlying point that my lord asks me is absolutely right, and it is one of the issues that has, in some senses, most bedeviled this whole area, has resulted in procedural toing and froing, actually was the basis upon which my learned friends' clients were saying that I shouldn't be entitled to a license at all because I'd taken a position in negotiations that what they were claiming was too high. That was why I was said to be unwilling. So in that kind of universe, it's hard for there to be complete rationality. I put this in slightly pejorative terms, and I haven't drawn your attention to all of the context of this, There's context from the European Court of Justice in the Huawei and ZTE case. There's context in the ETSI scheme where the concept of a willing license or willing licensee is an important one. We'll come on to that. But there is a final reason why it may matter, and that comes to my cross appeal. If and insofar as there are issues where conduct may be relevant on either side, and we say that conduct is potentially relevant, both in relation to issues of limitation and in particular in relation to issues of interest, as the judge in fact himself held, then one needs to examine the conduct of parties. And part of the reason for doing that is because one might, just to take one example on interest to foreshadow the arguments tomorrow, one might need to make a determination of what the date was that was the first reasonable date that a licensee could have entered into a FRAND agreement, because it is from that date that the court might consider that interest should be paid. And I'll develop that obviously at greater length. Equally, as my lords will know in limitation, there are certain circumstances where, as the judge acknowledged, if someone has strung something out or delayed or so forth, limitation might cut off their claims. I will develop that at slightly greater length, but those are the reasons why that kind of concept can matter in a case of this kind. And if one is dealing with very substantial sums that turn on it, and let us remember here that the sum that is potentially conduct dependent here is $70 million, these things potentially matter a very great deal.
Very good.
So I'm sorry to have gone on longer than
Not to worry, but I think we do need to break there, so we will resume at 10:30 tomorrow.
Rise of April.